today we are doing Unit 6, which is a part of the course MJM025 Media Ethics and Laws of PGJMC or MAJMC programs at IGNOU. This unit is about media laws and constitutional framework. Friends, in the previous units, we finished Block 1, which was dealing with media ethics and self-regulation, and we have moved on to Block 2. Unit 5, which is the first unit of Block 2, was related to Indian Constitution. And today we are on the second unit of Block 2, which is Unit 6, Media Laws and Constitutional Frameworks for journalists particularly. Let me take you through the unit structure and the learning outcomes of this session. In this unit, we shall study freedom of speech and expression. How does this entail the freedom of press in it? Article 19, limits to press freedom. We'll move on to the law of defamation, definitions and kinds of defamations, and also punishments for defamation, journalistic defenses against the law of defamation, and then we'll move on to Official Secrecy Act, contempt of legislature, dealing with what is the contempt of legislature, and some cases where this contempt can be understood better. So this is broadly the structure of this unit. Actually, in the previous unit, we have discussed that the Constitution of India is the supreme law of the land. We also discussed the salient features of our Constitution, which is perhaps one of the longest such documents in the world. For media persons and organizations, most important provision of the Constitution are Article 19A and Article 361A. These all things we have studied earlier, and today we shall move on to these particular press provisions in the Constitution. As has been told to you in the earlier lectures, there is no separate section in our Constitution named the press laws, but all the sections, all the laws, provisions, privileges are implying to the press like to any other citizen or profession. So, which are the particular laws that you as journalists must know is what our imperative today is. And we expect that after you go through this unit, either through this video lecture or through the printed study material that is sent to you by IGNOU, you would be able to describe the role of the constitutional framework, discuss the needs and importance of freedom of speech and expression for journalists, describe the law of defamation, explain the various journalistic defenses available to defamation and libel, describe the Official Secrets Act and its criticism, and you should be able to explain some important constitutional provisions on parliamentary privileges. So, after going through this unit, if you think you are able to do this, then you have probably gained whatever was intended to through this study material. Let us come to freedom of speech and expression. While normally freedom of press means freedom to write, freedom to print and publish, whatever one likes, anywhere, anytime, the fact is that this in normal circumstances is seldom possible or permitted. For any media person or organization to be able to function to their fullest potential to a meaningful, purposeful and satisfying scale, a full, total, complete freedom of speech and expression is a matter of necessity. But it is also a matter of concern. As the proverb goes, absolute power leads to absolute corruption. So, if you are totally free and not hindered, bound or any obstacles posed to you by means of laws, state, norms, ethics, then it would be a chaotic situation. And we don't want it, neither in the profession of journalism, especially not in the profession of journalism, I would rather say. The print media has some kind of inbuilt permanency in their operations. Audio-visual media generally lacks that characteristic. Therefore, there are separate laws that have been enacted for print and electronic media. Permanency, urgency, real-time reporting with 24 channel that are there. Every time 24/7 you have certain things put to you versus something that is on paper that you can keep forever and ever. It exists for eternity and this exists in urgency. So, they both have very diverse needs. Therefore, different laws, not to curtail or curb their freedom of speech and expression, but to put certain responsibilities while you are expressing your freedom. As I always said, My freedom or my rights are your responsibility, and your rights or your freedom is kind of my duty. Therefore, as a society, we need to have checks and balances for everyone. Of course, journalists are not an exception. Press freedom. Let's look at the historical overview. With all these debates, you might also be thinking, oh, one side you are saying you have to be free, the state should not interfere, you should not be put away by certain unethical things. And one side you are saying, oh no, you should have these laws which are curtailing, curbing, checking you. What is the thing? Since history, people have thought over, pondered and debated over these things. Actually, one of the strongest reasons for the freedom of press was given by John Milton in his famous kind of doctrine that we say. And an important philosophy for the freedom of press was also given by John Stuart Mill in his essay on liberty. We can safely say that these people were the early proponents for the freedom of press. They advocated that this is required. In the USA, immediately after the independence of the country, the freedom of press was acknowledged to be a vital part of the American Bill of Rights. In the United Nations Universal Declaration of Human Rights, it was recognized that freedom of press is the basic human right. With so much said that it is a right, why do we want to curtail it? You know, in India, we have had this freedom of press debate and it has a checkered history. Sometimes the press is thought to be so powerful, and at times, like in the times of emergency, it is totally curbed and curtailed. Sometimes it is flying high, and at other times its wings are cut down. So there is a checkered history in India to this. And all these debates globally in our nation bring us to how much of freedom of press is required, how much can be granted, how much should not be granted. And friends, as students of media laws and ethics, as students of journalism, you are the next generation who will probably put some amendments, some liberties, some curbs there, and we leave it to you to go further with this. Not that things have remained same. Society is evolving and so are we. And for you, the responsibility is further to make it evolved and make it what is appropriate for the society. Article 19 is about the freedom of speech and expression. We saw that in our previous lecture. Now, Article 19 tells you that you have the freedom to assemble peaceably without arms. You can form unions or associations. You can move freely throughout the territory of India. You can reside, settle in any part of this territory of India and can participate in occupations, trades or businesses that you choose to. So you are actually free to not only speak and express, you are also free to do all this, to assemble, to form opinions, to practice occupations, to reside. This is Article 19. Now there are limits to this freedom. And this Article 19, when it applies to the press also, same limits apply to press. There are limits to press freedom, governing that unless and until the sovereignty and integrity of India is not sacrificed. So when you do things in the name of my freedom of speech and expression, and it is dangerous to the sovereignty, integrity to the state of India, then this freedom has limits. Limits to press freedom are also more than to journal citizens, because you have that pen which is said to be mightier than the sword. You have that camera which can sting on anyone anytime. Therefore, there are more limits which are placed on these powerful media instruments, organizations and media professionals. The first one is security of state. You must help your country maintain friendly relations with foreign states. And if the press, by writing, by showing, by recording, by reporting, lead to dangers in the security of state or the friendly relations with foreign countries, then they need to be curbed. So these are limits to press freedom. Public order, decency and morality need to be maintained. If the contempt of court, defamation or any incitement to an offence is happening, then it is limited. In this unit, if you look at the SLM, that is a self-learning material that we've provided you, after this section, you will have check your progress. So you should think on these. What is meant by freedom of press? What are the limitations of press freedom that are provided by Article 19? So I encourage you to pause this video, think over or maybe discuss it with someone around you, your friend, colleague or your family on these issues. Now let's come to the law of defamation. Newspaper correspondents and reporters are often assigned to cover functions where you have well-known personal, political leaders who are invited to speak. And newspaper reporters day in and day out listen to such speeches, interact with these powerful people. While writing their news articles, media persons need to quote them in their day-to-day journalistic assignments, and they are expected to report truthfully, accurately and objectively. Whatever is said, report this. But we are all humans. At times, some of the people who are writing, reporting, editing the article, the news, the incident might be tempted to write or cast negative impression on the speakers or the interview's professional standing, their individual life or their private matters. As journalists, you will be privy to a lot of information. Now, do you need to give all this information to your public in the name of the public has the right to know, the nation wants to know, or do you want to only report what has happened and keep some things to yourself? This is ethically governed, of course, and also governed by law. As we said, certain limits are provided to how much can you express in the name of freedom of press. Now, there are different kinds of defamations and there are different kinds of punishments to those. Let's define this defamation. Now, it may amount to defamation to impute anything to a deceased person. If the imputation would harm the reputation of that person if living and is intended to be hurtful to the feelings of his family or other near relatives. It may also amount to defamation to make an imputation concerning a company or an association or a collection of persons. It may amount to defamation if an imputation in the form of an alternative or expressed ironically and it is published or broadcast. No imputation, however, is said to harm a person's reputation unless that is directly or indirectly in the estimation of others. It lowers the moral or intellectual character of that person or lowers the character of that person in respect to the caste or his calling, or it lowers the credit of that person. If it is believed in a state journally which is considered as disgraceful. If the imputation is true or in public good, it should be made or published. But whether or not it is in public good is a question of fact. So you might say, okay, this is harmful to this person's personal reputation, but it is in journal public good and therefore I have published it. But my dear friend, whether it was in the journal good or not, who will decide? If you cannot decide ethically, self-regulating or through your conscience, then comes the law of the state, which tells you, boss, no, it might seem in journal public good, but we don't see any good happening, we only see a harm happening. Then you will be liable to punishment. So, there are certain other things that when doesn't it amount to defamation? If an opinion has been made in good faith on the conduct of a public servant, in the discharge of the public functions or his characters, so far as his character appears in that conduct. If an opinion has been made in good faith on the conduct of any person touching any public question, or the publication has been made which is subsequently true as per the court's proceedings or the results of any such proceedings, then you have safety against the law of defamation. More safeties: if an opinion has been made in good faith or merit, if it has been made in a musical or a theatrical performance or a book which has been offered or submitted for review or critique, if you are quoting from that book, or it has been made by a person of authority or an author either by law or a lawful contract. So, this all passes the censure on the conduct of that person. Then you can say that this is the defense. But if it doesn't pass all these censures, then what is the punishment? The law of defamation provides that if a person is proved to have committed an act of defamation, he or she will be punished with simple imprisonment for a term which may extend to 2 years, or with a fine, or with both. However, the courts reserve the right on awarding such kind of punishments depending upon the gravity of the infringement of the law. The law also provides that if a person or an organization is found to be selling or offering to sell any printed material containing defamatory matter, knowing that it contains such matter, it shall be punished with imprisonment, fine or both. So you can claim your defense, oh, I was selling it, but I did not know that this book or publication contains defamatory material. Now it depends on the court whether to agree or believe your argument or to punish you. This brings me to the next section of this unit, which is on journalistic defenses under the law of defamation. Now, if there is a fair comment on any matter of public interest does not amount to defamation. The privileges that the press people have. In the name of fair comment, in the name of public good, what is the privilege? There are occasions when it will not amount to defamation if the report published in the public interest. It is considered the privilege in public interest. Truth and justification. If in criminal prosecutions of defamation, mere truth is said, okay, it was true, this is not a defense. Apology. An unconditional, absolute, unqualified apology is sometimes accepted by the courts. How to avoid defamation? This seems to be a very kind of a dangerous law. Oh, where are defenses, where there are not defenses, court will agree, not agree. It is better I steer clear of such kind of things. So, the ground rule I would say is keep yourself well informed on identical cases in the past in the media. Whatever has led to punishments, whatever has been considered as defamation, so information is your best defense. That will help you make better judgments. If you should acknowledge that without any grudge, I have written something, so you should be very quick to acknowledge it. It is okay to give your defense, an apology, an acknowledgement quickly to the court of law if you actually find yourself stuck in such kind of a case. Confirm and verify the facts to whatever extent deadlines and resources permit you. As journalists, you will usually find yourself saying, oh, where is the time? Where are the resources? They don't give me money to verify my facts. They are on my head to give a news just now. The urgency of the profession does not permit me to research. But whatever your time and resources permit you, friends, do research. What is true and what you can prove to be true are two very different things. Make sure opinions should not be based on false data that someone has given you. Verify your sources. Always indicate the source of a story, enumerating from the government departments, proceedings, officials or documents. This will save you a lot of trouble. Crediting your source will put the blame on that source and not on you, if at all you find yourself stuck in a position. Keep self-promoters, self-servants at an arm's length. People who give you their own press release saying, "Bhai, please publish this, na. Oh, this will go." Keep them at bay, friends. Always, invariably, get to the other side of the story, particularly that of the defamed person or the organization in question. If somebody gives you a source information, okay, this person is wrong, try and reach out to that person also before publishing the story from one side. Keep yourself updated with the story. Keep a vigilant eye on the rival contemporary publications in the town. What are they saying? People who are reporting on different points of view than yours also need to be in your research. So enough about the law of defamation. I hope this is a very, very important law, especially for the journalists, because you publish so many things, you report, and you might be stuck in ethics, laws, regulations. So we dedicated a major chunk of this session to the laws of defamation. Now let me come to another law, which is Official Secrets Act. This is an act of 1923. It was enacted in 1923. So, Official Secrets Act, why was the Official Secrets Act enacted in the first place? Of course, it was the British government where we were a colony, we were slaves, and they wanted to put this act, but we've retained it in the interest of the national security. The purpose and the background of why it was enacted is, of course, the colonial context. It was enacted during the British rule in India. National security to prevent and protect national secrets, prevent the giving out of the secrets, to control the information flow, regulate and control the flow of sensitive information, and provide a legal basis for prosecuting breaches of confidentiality. The objectives of the Act were to protect the national interest, to safeguard information related to security and defense, to prevent espionage, that is to determine against spying activities and maintain the public order, to prevent dissemination of information that could threaten the public order or state security. The key provisions in this act are given in section 3, which is penalties for espionage, section 5, which prohibits unauthorized communication of official information, and section 6, which has the power to arrest and search without a warrant. What is the importance of this kind of an act? Why has our constitution retained very strict kind of an act? The importance of this act lies in ensuring confidentiality of sensitive information. It protects national security and defense interests. But what is the major criticism about this act? So the basic criticisms are about the vague definition, where they say ambiguous terms lead to arbitrary interpretations. Terms like secret and confidential are not clearly defined, and therefore it is being misused against journalists. Potential of this act to be used to suppress press freedom. Journalists and whistleblowers can be targeted under the garb of the national security. There is lack of transparency, which is a major criticism against this act. Government actions and decisions lack accountability. The act can be used to withdraw information from the public and the media. In the name of this act, a lot of information is withdrawn later. Post-dated withdrawals are not uncommon. And there is also colonial legacy to this act. It is seen as an outdated and not suited to modern democratic values. Originally, it was defined and designed to serve colonial interests, but in a sovereign democratic state, what is it doing? I again encourage you to research on this act, that are these criticisms real? Where have people actually, faced this act? Recent amendments, however, have been made in the Official Secrets Act, where they have updated the act to address modern challenges in information security, and they have also enhanced the penalties for breaches related to cyber espionages, cyber secrets being given out. A balance is actually required, where you protect the national interests while ensuring freedom of the press and individual rights. I come to the contempt of legislature next. In this section, we discuss the concept of privileges. Now, the privileges of Parliament rests on the principle that a sovereign legislature should be able to perform its legislative and deliberative functions independently and effectively. Therefore, according to the Constitution itself, the privileges enjoyed by them are the same as those of the British House of Commons. Since this task is extremely responsible and rigorous, media persons who are assigned to report these legislative proceedings day in and day out are some of the most seasoned and highly experienced members of the Fourth Estate. You would usually find senior journalists reporting on the parliamentary affairs, because you need to exercise a lot of caution and a lot of awareness and knowledge about the laws in this kind of a proceeding. Now, what is contempt of legislature? Breach of privilege of either house of central or state legislature is usually known as the contempt of legislature, like the contempt of courts. While no distinct or clear-cut laws have been enacted so far to precisely describe the contempt of legislature, Article 194 of the Indian Constitution actually has the powers of India's parliament dictated in it, and Article 105 lays down the privileges of the state legislatures. Now, reporting of these proceedings, what should you keep in mind? In this respect, the most important is Article 361A, which was inserted in the Constitution by the Constitution's 44th Amendment Act. Article 361A is applicable for reporting of either house of the legislature of every state. This article provides protection to publishers of reports on parliamentary and state legislature proceedings. The objective of this article is to ensure freedom of the press and transparency in reporting legislative proceedings. Now, reporting of proceedings under 361A, the key pointers or key provisions that you have is immunity from legal proceedings. No person shall be liable to any civil or criminal proceeding of any court for publishing a substantially true report of the proceeding. In good faith reporting, you can have kind of a provision. Reports must be published in good faith and without malice. This applies to both houses of the parliament and the state legislatures, that is scope of this act. The importance of this act lies in the freedom of press, public awareness and transparency. It says that, it is very, very important because this act leads to safeguard the right to report on legislative matters. It ensures the public is informed about legislative debates and decisions, and it promotes openness in government proceedings. There are certain exceptions to it. One being expunge statements. No protection for reports of proceedings that have been ordered to be expunged by the legislature. If you've been told categorically that do not publish then, and you do that, then you do not have the journalistic defense. If it is false reporting, no immunity for reports that are not substantially true or are published with certain malice in your mind. Some cases of contempt of court. These cases illustrate the complexities and the legal battles that surround the contempt of legislature, highlighting the balance between the legislative privileges and individual rights. Let me take you through 3 of these cases very basically, which are very important when you are studying contempt of legislature. The first case, which is a very important case, is Keshav Singh's case of 1965. Keshav Singh, a member of the Socialist Party in Uttar Pradesh, wrote an allegedly defamatory pamphlet against a member of the Legislative Assembly. The Uttar Pradesh Legislative Assembly found Singh guilty of contempt and ordered his imprisonment. Now there was a legal battle. Singh challenged the Assembly's decision in the Allahabad High Court, which led to a constitutional crisis involving the judiciary and the legislature. The outcome was that the Supreme Court intervened and emphasized the limits of legislative privileges, ultimately ruling that the judiciary has the power to review the legislative actions. Second case, which was very important, is a case of 1996, which is the Shiv Sena case. Journalists from the Shiv Sena owned newspaper Samana actually published derogatory articles against the Maharashtra Legislative Assembly and its members. Now, this was thought to be the contempt of court. The assembly summoned the journalists and found them guilty of the breach of privilege and contempt of the legislature, and therefore these charges were put against them. The resolution in this case was the journalists apologized and the assembly accepted the apology, thereby ending the proceedings. So this tells you one thing: if you are ever caught, the court accepts apologies in certain cases as a defense. So a very recent case is the Arnab Goswami case of 2020. Arnab Goswami, a famous television news anchor, made allegations against the Maharashtra Legislative Assembly in relation to the Palghar lynching case. The Maharashtra Legislative Assembly accused Goswami of breach of privilege and contempt of his critical remarks against the assembly and its members. These were the contempt charges. Now the legal proceedings. Goswami challenged the assembly's notice in the Supreme Court, which ruled that Goswami must be given an opportunity to report to the charges and emphasized the need for fairness in legislative privilege proceedings. Friends, these 3 cases have been broadly discussed to give you an idea of what amounts to the contempt of the legislature. As reporters and journalists, what are your defenses and what can actually happen? To sum up this unit, I can say India is one of the largest democracies in the world, and the mass media in the country constitutes a very vital organ of its overall structure. These legal enactments are to help and guide you as a media person to function in such a way that you are not caught on the wrong side of your profession, endangering civil or criminal proceedings against you or the media outfits that you work for. We here discuss the concept of freedom of speech and expression, the laws of defamation and libel, the journalistic defenses such as fair comment, privilege, truth, justification of these laws. This is all from my side for Unit 6, which is the second unit of your blog on media laws of the course MGM 025. I encourage you to go through the study material that we have provided and also through certain other readings from the list of further readings given in the end of your unit in the study material. Wish you a very happy learning experience with us. Thank you for tuning in and listening.